Beyond Law CLC, and ULS Punjab University Chandigarh. Welcome you all to another session which would give us the insights to various aspects. Since the succession has its own challenges, and if to understand as a lawyer, as a student of law, as a professor, or for that matter anyone, if the concept of how the succession devolves within the Hindus is a concept which ordinarily one wants to know, and especially in the wake of the amendment made in 2005, and what is the effect of the latest judgment, whether it will apply retrospectively, whether it will apply prospectively, what is coparcenary, what is a personal share, all these issues, if one gets the insight in a seamless manner, one always gets enlightened in the right perspective. And the confidence, not of the student of law, that is the lawyer or a judge, for all that matter, is much better because it's large scope. The act is quite large. Primarily, as we had just discussed with Justice Mr. N. Manokaran, the advocate, to give the insights, and if time permits, we can go beyond Section 6 as the time would be. We will also have some Q&A session as in the normal routine we have, but again, the questions would be in and around Section 6 of the Hindu Succession Act, and not any other topic or any this thing. Mr. N. Manokaran does not need any introduction as such. He has been practicing since 1995, and since he has been taking issues which are of relevance, it speaks from the volume that around 1700 judgments are reported, and it shows that ordinarily those who have been practicing, and even when the student one examines, that the judgments which are reported are invariably where the legal aspects are to be touched. I'm just reading the messages, as to some people it's not audible. Could you just post it on the chat box as to whether it's audible or not? Then the necessary steps can be taken. And he has also been a regular resource person in the Tamil Nadu Judicial Academy since the year 2012. And teaching in the Judicial Academy itself gives the insights that the speaker is well taken for the purposes of making it understandable not only to the lawyers, but also the academy, which is considered to be the nursery where the judicial officers are also given insights by the experts. Without taking much time, I will call upon Mr. N. Manokaran to give the insights of Section 6, primarily of the Hindu Succession Act. It's more like a primer. Over to you, Mr. N. Manokaran. We are deeply obliged on behalf of Beyond Law CLC and ULS that you are giving the insights. Right, sir.
Very good morning to one and all. It is a great pleasure, and indeed I am happy to be present before you through this webinar. I thank Mr. Vikas and his group for giving this opportunity to share my views and thoughts in the Hindu Succession Act, which is always troubling us in the civil court practice. Further, I am one of the disciples of Honorable Justice S. Nagamuthu. I am here before you only because of him. Therefore, I thank him wholeheartedly for giving me this opportunity to share my views. Hindu Succession Act 1956. It is one of the important act which came into force. Constitution in 1950. A few important enactments came, like Hindu Marriage Act, Hindu Adoption Maintenance Act, then this Hindu Succession Act, Guardianship and Wards Act. All these acts have come after the Constitution. Before that, we did not have any codified law insofar as succession laws are concerned. So, Earlier, this Hindus were governed by only Sastric and customary laws. We didn't have any codified laws. Even though this law is an age-old, but still it is ageless. And even after the codified act came into force in 1956, still we have been retaining the concept of co-parsonery, which has been in force for decades together. Before this act 1956 came into force, there were a few enactments. To my knowledge, the Hindu Law of Inheritance 1929 came into force, which gave them right only to the few categories of peoples, namely sister's daughter, son's daughter, daughter's daughter, and sister. Then thereafter another legislation, that is Hindu Women's Right to Property Act 1937, which is the basis for the subsequent 1956 enactment, because only under this 1937 act, right was given to the widows to have a right to property, limited right to property, and she is entitled to get right as equal to that of her son in the property of her husband. But that right is only limited right. Thereafter only the Hindu successor in 1956 came into force. In fact, there was one view was taken that this Hindu Women's Right to Property Act has no application to the agricultural lands. And this view was put under challenge before the Federal Code in 1941 Federal Code, page number 72. The legislative competence of the act was put under challenge, and the Federal Court has taken the view in 1941 Federal Code, page number 72, that it is only applicable, it is not applicable to the agricultural lands. Then after a few years, this 1956 act came into force. Before going to the act, because there are a lot of younger members who are listening this discussion, and my aim is also only to target them, because there are a few fundamentals we should know before understanding the entire concept of this Hindu Succession Act. The fundamentals are: one, joint family, Hindu joint family. What is Hindu joint family? And joint and undivided, a joint and undivided Hindu family is called joint Hindu family. In a joint, it's a larger body, because co-parsonery is a smaller body within the Hindu joint family. So Hindu joint family is a larger body which consists of male and female members, a common ancestor, his sons, and common ancestor's wife, mother, and son's wife, and wives and daughters, all constitute a Hindu joint family. Even a single male member with his wife, daughter, and mother, unmarried daughter, mother, and wife, can constitute a Hindu joint family. The Hindu joint family, female members also can be there, but not in co-parsonery. Co-parsonery is concerned, only male members would be there in co-parsonery. But as far as Hindu joint family is concerned, even a single male member constitute a joint family along with his wife, unmarried daughter, and mother. It is permissible in law. Hindu joint family is not only for property. Whether Hindu joint family has property or no property, it makes no difference. But Hindu joint family is not only for property and also for food and worship. So the family is for different purposes: for enjoyment of property, for worship and food, everything. All are living under one roof. So Hindu joint family is a larger body, and whether property is there for joint family or not, it makes no difference. They can constitute a joint family. So then we'll go to co-parsonery. What is co-parsonery? Co-parsonery means only a male members in the family can constitute a co-parcenary. Co-parceners, co-parson is a smaller body. Otherwise, I can call it as an inner cabinet of the joint family. So, joint family is a larger body in which co-parson is a smaller body. In the co-parcenary, only male members will be there. Female members till 2005. Prior to that, there were state enactments. So, before the daughters were inducted as co-parceners, only male members constituted a co-parcenary. In a co-parcenary, it is neither a creation of statute nor created by any parties. It is an institution by itself. Co-parcenary is an institution by itself. The Supreme Court in AR 1976 Supreme Court 109, in AR 1976 Supreme Court 109 has elaborately dealt with and held that co-parcenary is an institution. It is not a creature of statute. And co-parcenary, in the co-parcenary, a co-parcener gets right by birth. This is birth. It is birth by birth. You will get right in the co-parcenary. And co-parcenary consisting of 4 degrees, namely a common ancestor and his son, grandson, and great grandson. So all these 4 constitute a co-parcenary. Suppose it will not go beyond this 4 degree. Take an example: A, great grandfather; B, grandfather; C, son; D, grandson. Suppose if D gets a son by name F, then he will not come within the purview of co-parcenary until A died. So until the great grandfather died, the 5th degree will not come within the 4 corners of the co-parcenary. So co-parcenary includes only 4 degrees. Similarly, if a male ancestor inherits a property from the paternal side, namely father, grandfather, and great grandfather, that is 3 degrees above him, a male person, a male ancestor gets a property from the 3 degrees above, namely son, father, grandfather, and great grandfather. Then that property he will pass on to the 3 degrees below him, namely son, grandson, and great grandson. So the co-parcenary consisting of only 4 degrees and 3 degrees above and 3 degrees below, but it will not exceed 4 degrees. If even two co-parceners can constitute co-parcenary, even 3. Suppose grandfather is no more, great grandfather is no more, grandfather, father, and son can constitute. If grandfather and great grandfather are no more, then father and son can constitute co-parcenary. Similarly, if father and son alone are there, they can constitute a co-parcenary. So in the co-parcenary, always all the co-parceners will have right over every part of the property. Their property may not be identifiable with the specific boundaries, but they have right over the entire co-parcenary property. Similarly, in case of death, the share of the existing co-parceners will increase. In case of birth, then the share of the existing co-parceners will decrease because a new co-parcener has come. So similarly, yes, please understand that in the co-parcenary is concerned, the share in the property will increase in case of death. Share in the property will decrease in case of birth. So this is the basic concept we should understand about the co-parcenary. So co-parcenary is still continuing even after the 1956 Act and State Amendment under Section 29A, and even after 2005. So we should keep this basic principles for the purpose of understanding this co-parcenary system. In fact, I would tell one judgment of the Honorable Supreme Court in 1969, 2 SEC, page number 33. 1969, 2 SEC, page number 33. The concept of co-parcenary has been elaborately discussed by the Honorable Supreme Court. In this judgment, the salient features of the co-parcenary has been laid down. Let me read the guidelines one after another so that the listeners could easily understand. In 1969 2 SEC 39, the salient features of co-parcenary has been laid down as under: 1. Lineal male descendants of a person up to third generation acquire right by birth in the ancestral property. 2. Such descendants at any time can ask for partition. 3. Till partition is effected, each member of the co-parcener having right over the entire extent of the property. 4. As a result of such co-ownership, the possession and enjoyment of the properties in common. 5th one, the no alienation of the property is permissible except for legal necessity with the consent of the other co-partners. The last one, the interest of the deceased member lapses on the death of the survivors. So these are all the basic features the Supreme Court has identified. Apart from that, very recently, the Honorable Supreme Court in AR 2019, Supreme Court 3098, AR 2019 Supreme Court 3098, the concept of co-parcenary and whether the act is retrospective or prospective, all these issues have been elaborately discussed. You take note of this citation. We'll go to the effect of the 2005 little later. Similarly, in 2018 15 SEC 662, the concept of co-parcenary has been discussed. So these three judgments, you please keep it in mind to understand the basic concept of co-parcenary. Then next one, ancestral property. Ancestral property means the property inherited by a male from his father. The property inherited by a male from his father, grandfather, and great-grandfather. It is otherwise called unobstructed heritage. Ancestral property is otherwise called unobstructed heritage. Suppose the property inherited from other than this ancestral source is called obstructed heritage. And this issue, how we could identify this ancestral property, as now we have discussed, whether it is obstructed heritage or unobstructed heritage, we have to find out the source from which the property reached the hands. So this position has also been discussed by the Madras High Court elaborately in 2012 7 SEC, 2012 7 SEC, page number 414. This concept of ancestral property has been discussed in 2012 7 SEC 414. So these are all the basic things we have to appreciate before going into the main subject. So when there was no codified law before 1956, our leaders then, namely Pandit Jawaharlal Nehru, Mahatma Gandhi, Madan Mohan Malaviya, Dr. Ambedkar, all thought that in order to treat the daughters as equal to that of son, this concept of co-parcenary should be removed. So that was the attempt made. In fact, they have also they had constituted a committee, and Hindu Code Bill was virtually framed by B.N. Rao committee, and that committee report was piloted by Dr. B.R. Ambedkar with a view to abolish the entire co-parcenary because it discriminates the daughters. In fact, you know well, we have two major sets of schools. One, Dayabaka, which is exclusively applicable to eastern states, namely West Bengal and other neighboring states, and the rest of the states are only following Mitachara law. So in Dayabaga, in fact, daughters have been treated equal to that of son, and there is no concept of co-parcenary in Dayabaga. So the same benefit was sought to be extended to the other areas, other states also. So when the Hindu Code Bill was presented for discussion, ultimately the Hindu Succession Act came into force. And even in the 1956 Act, the legislature have not completely taken away the concept of coparcenary, and the old concept of coparcenary has been virtually retained in the main section 6 of the Act 1956. So if you read the preamble of 1956 Act, it clearly says that there is no new enactment was introduced. They say the 1956 Act is only to amend and codify the law relating to the succession, interstate succession. The very beginning, the very preamble of the Act is very clear that the very concept of this 1956 is to codify, amend and codify the law relating to the interstate succession. Then it retains the power of testamentary disposition under section 30. So no doubt Hindu male can execute a testament under section 30 of the Hindu Succession Act, and there is no, in fact earlier we have a separate act also for law of wills, and after this 1956 enactment, a specific provision has been incorporated under way of section 30, which enables a male Hindu to deal with his property way of testamentary disposition. So in the event of no testamentary disposition, the succession and the property has to go under two provisions. One, section 6, succession in respect of co-personal property. Another, section 8, general rules of succession. I would say section 6 is almost an exception to section 8. So section 8 is general rules of general rules, in which section 6 is an exception. Then let us go to the very few important provisions of the Act. You know well, section 2 is very clear that this Act is applicable to Hindus, Buddhist, Jaina, Sikhs, these are all the religions which are following this Hindu law, and it is not applicable to Christians, Muslims, even Jews, Parsis. The Act has no application, and section 2 is very clear. Section 4 has an overriding effect. If you read section 4, which says that save as otherwise expressly provided in this Act, any text, rule, interpretation of Hindu law or custom or usage of as any part of that law in force immediately before the commencement of this Act shall cease to have effect with respect to any matter for which provision is made under this Act. B, any other law in force immediately before the commencement of the Act shall cease to apply to Hindus insofar as it is inconsistent with the provisions of the Act. So any custom or any rule or any text which was already there automatically come to an end the moment Act 1956 came into force. But if those if any other custom which was prevailing, which is not inconsistent with the provisions of this Act, then that can be followed. A classic judgment of the Supreme Court regarding the applicability of section 6 in 2007, 5 SEC 561. 2007 5 SEC 561. This is also from Punjab State, and Supreme Court has extensively dealt with the effect of section 4 as well as the custom. If custom which has been proved and established, then that will prevail, is the view taken to the Supreme Court in 2007 5 SEC 561. Then let us go to section 6. Section 6, we can categorize section 6 under 3 classifications. 1, pre-amended section 6. Then state amendments introduced by of section 29 capital A. Then 3, post-amendment 2005. Prior to amendment, that is the original text of section 6 reads as follows: devolution of interest in co-personal property. So we are only dealing with co-personal property. If it is a separate or self-echoed property, then rules of succession comes under section 8. So section 6 exclusively deals with the co-portionary property. When a male Hindu dies after the commencement of the act, I am reading the pre-amended provision. When a male Hindu dies after the commencement of this act, having at the time of his death an interest in the Mutachara co-portionary, his interest in the property shall devolve by survivorship upon surviving members of the co-portionary and not in accordance with act. So we should keep this particular word, namely his interest in the co-portionary property, his interest in the property. So not the entire property. Then how his interest in the property could be determined? Then we have to read the proviso. Proviso says, provided that if the deceased had left him any female relative specified in clause 1 or male relative specified in that clause who claims through such female relative, the interest of the deceased Mutachara co-portionary property shall devolve by testamentary or intersuccession as the case may be under this act. Explanation 1 makes it very clear that for the purpose of this section, the interest of a Hindu Mutachara co-portioner shall be deemed to be the share of the property that would have been allotted to him if a partition of the property had taken place immediately before his death, irrespective whether he was entitled to claim partition or not. So here, way of explanation 1, the legislature had introduced a concept of a notional partition. It's only fictional partition. Actually, Hindu male died when the issue has come up. The Hindu male died, but we have to presume as if there was a partition while he was alive. Take an example: father, mother, one son and one daughter. Suppose if there was no female heir, take an example, only father and son alone are there. Neither mother nor daughter are available. Only father and mother alone are there. In such case, the moment father died, the property will reach the hands of the son, because son is the only surviving co-portioner. There is no other person. So once a common ancestor or a co-portioner died, soon after his death, the property will reach the hands of the remaining co-portioners. In case, proviso says, in case there are female heirs as specified in clause 1. Take an example. The same illustration will take. Father left behind his wife, mother, and one son and one daughter. So here there are two female legal heirs as per clause 1. Who are they? Wife as well as daughter. So wife and daughter both are clause 1 female heirs as per schedule of the Hindu Succession Act. So in this case, we have to apply this notional partition theory. Namely, we have to assume as if there was a partition before the death of the Hindu who died. So by legal fiction, a notional partition theory has been introduced by of explanation 1. So we have to assume that there was a partition while the person, Hindu male, was alive. If there was a partition, what will happen? Then out of 10 acres, 5 acres will go to father. The another 5 acres will go to the son. And after the death of that father, then father's share again has to be divided among all the class 1 legal heirs, namely son, daughter, as well as wife. So I'll give again. I will reiterate. Hindu male died, leaving behind his wife, son, and daughter. If the notional partition theory is applied to the present case, then during the lifetime of the father, the property would have been divided equally by father and son, because both are co-portioners. Then after that, fathers of will again divide among all the 3, namely again son and daughter and mother, wife. All the 3 will get the that half of the father's share. So So now son is already having half share, and he is again getting 1/3 of his father's half share. So now as per the proviso to old section 6, now we get right to the property, that is the son is getting larger extent, and the female heirs are also getting share as only class 1 heirs. They were not given full right or equal right as that of the son. Only right given by treating them as class 1 heirs. And this position has been discussed in number of cases, because son is getting under 2 mode of succession, whereas daughter and other female legal heirs are getting from only one source. So this was the position. And so here the old before amendment, daughter was not a co-partner, only son was there. So this position continued from 1956 to 1990. In 1990, a lot of amendments were brought in under various states by inserting section 29 capital A. Firstly, Andhra Pradesh brought state amendment by elevating the daughter who remained unmarried yes on the date when the act came into force to a position of a co-partner. So in order to, that was the state amendment. So in order to claim the benefit of this state amendment, the daughter should have remained unmarried yes on the date of the state amendment. Following Andhra Pradesh, in many other states like Tamil Nadu, there was an act 1 of 1990 which came into effect on 25/3/1989. 25/3/1989. So yes, on 25/3/1989, the daughter should have remained unmarried, and both the father and daughter both should be alive. If father died before that, then succession opens as per 1956 enactment, not claim the benefit of A. Similarly, for Karnataka and Orissa, Kerala, all these states have introduced section 29A way of state amendment, and thereby the daughter was elevated to the position of co-partner as that of the son. But subject to rider that she is not entitled to claim share beyond. She is entitled to claim provided she should have remained unmarried. And this position came up before the Madras High Court as to whether it is applicable to the pending proceedings. Whether it is applicable to pending proceedings. Because suit would have been filed earlier. This act came into force on 25/3/1989. So whether the amended act could be applied even to in all these states, the similar problem arose in all these states. Whether this amended act could be applied to all the pending proceedings, namely, then the Madras High Court in 1991, as 1991. One Law Weekly, 1991, One Law Weekly, 97. The Madras High Court has taken the view that yes, on the date when the act came into force, if father is alive, then the benefit of the amended act can be extended to the daughters also. Why I am dealing with this amended the state amendment is the 2005 Act is only an enlarged version of the state amendment. Therefore, because in many states all over India have introduced this state enactment way of insertion of section 29A. Therefore, I want to elaborate the implication of the state amendment so that we can easily understand the concept of the amended 2005 Act. So in 1991, One Law Weekly that the Act has only prospective application. It has no retrospective application. Suppose father died before the cutoff date fixed under the act, then the law which was prevailed then will apply and not the amended act. That was the view taken. Simultaneously, at the same time, again the Andhra Pradesh judgment, a case was filed before Andhra Pradesh High Court in AR 1990 AP 263. In AR 1990 AP 263, Narayana Reddy versus Sai Reddy. Almost similar issue had come up for consideration. That matter went to Honorable Supreme Court. The Honorable Supreme Court in Sai Reddy versus Narayan Reddy reported in 1991 3 SEC 647. 1991 3 SEC 647 held that in the absence of any final partition, between the parties or any final degree, then the benefit of this social welfare legislation should be extended to all the pending litigations. So the Supreme Court has held that the Supreme Court has not gone into the issue as to whether father was alive or not, but Supreme Court has gone to the extent of saying that even assuming that litigation is pending, that would have been filed before the state act came into force. But the fact that it is pending before court and no final decision was taken and no final degree was passed, then even in those cases, this benefit of 29A can be extended. That was the view taken by the Supreme Court in 1991 3 SEC 647. Why I am stressing this judgment? Because this judgment has also been followed even to 2005 Act. The matter is now sub judice before the larger bench, but still there are two judgments of Supreme Court reported in 2011 6 SEC 462, 2011 6 SEC 462. That is Prema case, Prema. Then 2011 9 SEC 788, 2011 9 SEC 788, Ganduri Kodisrama. In both these cases, the Supreme Court has applied the law laid on in Sai Reddy in 1991 and held that even respect of this 2005 Act, when list is pending before the court, either before the trial court or before appellate court or before High Court, Supreme Court, irrespective of the fact, when matter is pending, then for pending matters, unless final degree is passed, then the benefit of the 2005 Act has to be extended, is the view taken by the Supreme Court in these two decisions, following the judgment of Supreme Court in Sai Reddy case.
Mr. Manokaran, I have received 2-3 messages from people that they say slightly go slow because you know the subject very well. Some people are taking notes. They have not been able to cope up with that.
Very sorry, sir. I will follow that. Very sorry.
Yeah, no, not sorry. But once we are trying that people should learn the subject.
Yes,
so sometimes it is just like you are an expert of T20 and suddenly somebody says to play 5-day match. So people would like to, that. I am seeing large number of participants are making the notes. So I think even the stenographer will not be able to catch up. Right, sir?
Thank you, sir. I am also not an expert. I am also student of law.
No,
anyway, I will slow down. True, sir.
No, the question is that they should be able to cope up.
Sir, certainly, sir.
The smile of like Ramshad and all shows that they've actually acknowledged that yes, it should be slow.
Right, sir. Right. Then, yes, per this state enactment, we have seen, even though the act came into force on a particular date, the Supreme Court has not taken note of the date on which the succession opens. Namely, you know well, in order to claim the benefit as a co-partner, father should be alive. If father died before the state amendment, then the act which was prevailing prior to the amendment alone will prevail, and the new act has no application. That was the consistent. That was the view originally taken by the Madras High Court in 1991 law weekly. But because of Sai Reddy, the position has been completely changed. While so, yet another case came up before the division bench of the Madras High Court, headed by the very same judge, who dealt with 1991 1 Law Weekly 97, wherein the Madras High Court has taken the view that the Act has only prospective application and it has no retrospective application. That was the view taken in 1991. But because of this Sairidi case, again, the Division Bench of Madras High Court in AR 1994, Madras 647, the Division Bench of Madras High Court, in fact, the judge who dealt with 1991 was a party to the Division Bench in 1994. But he has no other option except to follow the law laid down in Sairidi case. Therefore, the Division Bench in Sanmugadayar case reported 1994 Madras, AR 1994 Madras 647, held that in view of the Sairidi case, the amended act is applicable even to the matters which are pending before the court. So, in none of these judgments, including Sairidi, the implication or the effect of the death of the father before the act came into force has not been taken note of. Therefore, the same error inadvertently or somehow has been carried out. Even the subsequent decisions of the Honorable Supreme Court, which you have already noted, that is 2011 6 SEC 462, then another 2011 9 SEC 788. In both these judgments, the earlier view of Sairidi alone has been followed. So this was the position. Then 2005, what has happened after this 1990 Amendment Act? In various states have elevated the daughter to a position of a co-partner. So between 1990 to 2005, in many of the states in India, daughters have given special credit. While so, the legislature thought it fit to eliminate this distinctive discrimination shown to the daughters. So the Law Commission also had filed its 174th Law Commission report, 174th Law Commission report in May 2000, and suggested various amendments in the Hindu Succession Act. One of the major amendments suggested by the Law Commission was to remove the gender inequality among the male and female, to removal of Section 23. Removal of Section 23 deals with the right over the house. Then this was again discussed by the legislature, and you know well, this succession law comes within the entry 5 of list 3, entry 5 of list 3 of the Constitution in the Schedule 7, concurrent list. Since succession law comes under concurrent list, the central government thought it fit to introduce a new enactment for the purpose of the extending the benefit to the daughters in the entire country. And accordingly, this 2005 Act 39 of 2005 came into force on 9/9/2005. I am going to deal with two important dates. One, 9/9/2005. That is the date on which the Act 39 of 2005 came into force. But actually, the bill was placed before the Rajya Sabha for discussion on 20/12/2004. Therefore, even under the amended Act, any alienations or partition or disposition or even testamentary disposition which had taken place before 2012-2004, that is the date on which the bill was placed for consideration before the Rajya Sabha. So anything happened prior to 2012-2004 has been retained, and it will not be disturbed. So anything happened or any disposition had taken place, any sale had taken place, any partition which took place or any will which had a given effect before that date can't be disturbed because of this 2005 enactment is the view taken by the legislature. Accordingly, the new act has come. Now the issue arises. Another issue has come. After this central act, what is the effect of the state act? You know well, Article 254(2) of the Constitution, Article 254 of the 254 Clause 2 of the Constitution says, if there was any state enactment, subsequently, if the central act has come in respect of the very same subject, then that central act alone will prevail over the state act. So, the moment the central act came into force, that is 2005 came into force, then automatically the state enactments in various states, namely Section 29A, which was there in a number of states, as I said, Tamil Nadu, Andhra, Karnataka, Orissa, as well as Maharashtra, all these state enactments have gone. It has no effect. But I would say one more thing. Suppose even after this central act, if the state has decided to retain the original position, they cannot retain the original act which has in effect nullified by the central act, but they can reenact a new law on the very same subject to suit their convenience, but they should place it before the president. They should get the assent of the honorable president, and they should also apprise the position that there is a central enactment, and we don't want to give effect to the central enactment in our state. So they should enact a new law, and they should get the assent of the honorable president. Then only they can implement the state enactment. So this position has been well discussed by the Honorable Supreme Court, 3 Justices bench of the Supreme Court in 1995 4 SCC, 1995 4 SCC 718, 1995 4 SCC 718. So accordingly, once this state central enactment has come, then automatically the state act goes, and this central act alone will prevail. Now let us go to the salient features of this 6 of the act, because the heart of the topic today is only the implications of this section 6, pre-amended or post-amended. Now let us go to the salient features of this section 6 of the amended act 2005. We have already seen before amendment, the main section of section 6 retains the co-parcenary and survivorship. The proviso alone paves the way to the class 1 female heirs to get right as class 1 heirs, not as co-partners. So, if old section 6, if there was no female heirs as per class 1, then the entire property will go to the hands of the living co-partners. Suppose if a deceased co-partner left behind a female heir in class 1 as per proviso to section 6(1) of the pre-amended act, then notional partition theory has to be applied, and thereby the property has to be divided. So that was the position earlier. And after this amendment came into force, the very object behind this act is only to treat the daughters as co-partners. So as like son, now daughters are also entitled to get right by birth. So they are by birth they became a co-partner under this act 2005. This act, I have said, came into force on 9/9/2005. The very beginning word of section 6(1) says that on and from the date of the commencement of this act, the daughters became a co-partner by birth. So the act, very reading of this section clearly says that only from the date on which the act came into force, the daughters become a co-partner. And here there is no discrimination as like the marriage and in the state act. We have seen the state act imposes a restriction on the married daughters. As far as 2005 act is concerned, whether daughters born before 1956 or born after 1956 make no difference. Similarly, whether daughters born before 2005 or born after 2005 makes no difference. So the date of birth of the daughter has no relevance at all. That is the most important aspect. Similarly, the father must be alive. Yes, on the date when the daughter and father both should be alive. Yes, on the date when the act came into force. In fact, in 2006, 2 SEC, page number 36, 2016, 2 SEC, page number 36, the Honorable Supreme Court, in Prakash versus Pulavadi case, clearly held in paragraph 17, a living daughter of a living father. Supreme Court has used the very same word, living daughter of a living father. Therefore, daughter and father both must be alive, yes, on the date when the act came into force on 9/9/2005. Similarly, whether daughter married or unmarried makes no difference. So the only restriction is that the for both father and daughter must be alive on 9/9/2005. Two, the property should be available for partition. Suppose if already partition had taken place before 2012-2004, then we can't do anything as per the new act also. So these are all the basic things. Similarly, now daughters shall have the same rights. Daughters shall have the same rights as that of the son in the co-possession property, and the daughters also gets that right. Yes, with all incidents of co-possession. It's almost like their separate property, and they can deal with it even by invoking the testamentary disposition under section 30. So after this property come to their hand, they can treat it as that of their property with all incidents of co-possession, and they can also deal with under section 30 of the new act. Similarly, daughter also gets that property with all liabilities in respect of the co-possession, but there is no pious obligation. The act has
since there are a large number of students and we have not explained what is co-possession, just explain in a minute what is co-possession and what is class 1 here, because students will not understand what is co-possession.
I will do that, sir.
Yes,
I have already in the beginning of the discussion, I have explained about
co-possession. No, but since participants joined late also, only on that factor.
Yes, sir. Co-possession, yes, I have already said that a Hindu joint family is a larger body. Hindu joint family is a larger body. It includes male and female heirs. There is no restriction at all. Take an example. My father, my mother, myself, my brother, and my wife and my brother's wife all constitute a joint family. Here, both male co-partners as well as female members are there. So, it is a joint family consisting of male and female members. Even a single male member can constitute a joint family. Take an example. I and my wife and daughter, unmarried daughter, can constitute a joint family. There is no difficulty at all. This joint family, not only for property, joint family may have property or may not have property, it makes no difference. Joint family, Hindu joint family is concerned, it is not necessary that it should have property. It is not necessary. If it has property, no difficulty at all. If no property, then no, there is no, we need not worry about it. Similarly, in the joint family, not only for property and also for food, worshipping right, and all living under one roof. So these are all the basic concept of co-possession. Hindu joint family. It's a larger body. Within that Hindu joint family, the inner cabinet of the Hindu joint family is the co-possession. In the co-possession is concerned, we have already seen both male and female members would constitute a Hindu joint family. Whereas co-possession is concerned, only male members can constitute. How? Take an example. I am alive. My son is there. My father is there. So we three, only male members, that is my father and myself and my son, three would constitute a co-possession. Suppose if no son to me, myself and my father could constitute a co-partitionary. Myself, my father and grandfather who is alive, both, all the three could constitute a co-partitionary. So co-partitionary consisting of only male members. Those male members gets right by birth. So the birthright was given to the male members. You know well, only in 2005 daughters were elevated to the position of a co-partner. Till such time, only male members were there. Suppose that co-partner is concerned, it cannot go beyond 4 degrees. Take an example: A, great grandfather; B, grandfather; C, father; D, son. So these 4 degrees, that is son, father, grandfather, great grandfather. Suppose that last co-partner, namely D, married and gave birth a son, that is E. That E will not come within the purview of this 4 degrees, because co-partnership can't exceed 4 degrees. Only 4 degrees should be there to constitute a co-partnership. Even minimum 2, maximum 4. Minimum 2 and maximum 4 co-partners can constitute a co-partnership. Single person can't constitute a co-partnership. Single person gets the property, then you will get it as suppose if suppose if D alone is available, A, B, C, that is great grandfather, grandfather, father, all the 3 died. Then D alone is there. He will get the property as that of absolute property, and there is no co-partnership. But the moment the son is born to D, then a new co-partnership is constituted. That is the basic concept. Similarly, you please see, if the co-partnership is a male ancestor gets a property from the earlier 3 degrees, any one of the earlier 3 degrees, he gets the property. Then that property he can pass on to 3 degrees below his line. That is, D gets the property from A, B, C. That is great grandfather, grandfather, and father. So now D alone is there. He can pass on this property to his 3 generations below, namely E, F, and G. So there must be 3 degrees, the 4 degrees, not beyond that. That is the basic concept of. Suppose similarly in the co-partnership, if a person, one of the co-partner died, A, B, C, D, we have seen 4. One person died. On death, you see the share of the existing co-partners increases. Similarly, if there were only 2 or 3 co-partners, another person born, then by this birth, the co-partnership enlarges. So now the 3 share has to be divided by 4. Therefore, always in co-partnership, by death the share will increase, and by new birth the share will decrease. So this is the concept of co-partnership. And I have already said one leading decision of the Honorable Supreme Court in 1960, AR 1969 to SEC, AR 1969 to SEC 33, one of the leading decision of the Honorable Supreme Court regarding this co-partnership concept. And very recently, the Honorable Supreme Court in AR 2019 Supreme Court 3098, there are a number of judgments, and I have given only leading decisions. In fact, yet another judgment of Rohit Chauhan 2013 9 SEC 2013 9 SEC 417. Then 2018 15 SEC 2018 15 SEC 662. These are 4 judgments. You please keep it in your mind. If you read these 4 decisions, you can easily understand the entire concept of co-partnership. In fact, I have elaborated in nutshell about the concept of co-partnership in the Hindu joint family. And these judgments, Supreme Court has clearly, first citation is 1969 to SEC 33. 69 to SEC 33. So this was, these are all the basic things we have to take note of while considering this concept of co-personality. Now let us go to the amended post-amended 2005. So in the amended act, we have seen daughter has been elevated to a position of a co-personer, and the very beginning of section 6.1 says that daughter of a co-personer. The word used under section 6.1 indicates that only daughter alone has been elevated to the position of a co-personer, and neither the mother or sister has not been elevated. So if different interpretation has to be given, then the suppose, as I said, suppose father died before the act came into force, then the legislature in their wisdom definitely would have included the word sister, sister of a co-personer. They have not said so. They have clearly said only daughter of a co-personer. That means to make the daughter as a co-personer, that co-personer father must be alive. That is why the words have been coined in such a way by the legislature. Then we have seen that she gets the right as equal to that of son in the family, and there is no pious obligation. The any debt incurred by the father, grandfather, great grandfather before the act came into force, then the creditor can proceed only against the son, and the creditor cannot proceed against the daughter. So daughter is not liable for the past debts. So, and the pious obligation has been completely removed. This 2019 9 SEC Rohit Chauhan is 41417, equivalent to AR 2013 Supreme Court 3525. Then let us go to this again. In this new act, section 6, the concept of notional partition theory has been retained. Take an example. Act came into force on 9/9/2005. Father died subsequent to the act came into force. Then daughter, suppose daughter has chosen to file a suit as on today. The father is no more. So for daughter has to apply the notional partition theory and has to decide whether on 9/9/2005, when the act came into force, whether if the notional partition theory is applied, then what would be the share allotted to all the co-personers. So that concept that has to be applied. So notional concept, fictional partition theory has to be applied for the purpose of ascertaining the share of the daughter. So suit would have been filed long after the act came into force, but on the date of filing of the suit, we have to presume daughter is alive, but father may not be alive. But daughter has to apply the fictional partition, namely what would have been the share in the event of any partition which had taken place before the father's death, that is after the act came into force on 9/9/2005. By applying this fictional partition theory, we have to ascertain the share, and then equal shares to be given to the daughter. In fact, section 6.1 proviso as well as section 6.5 of the amended act has made it very clear that anything happened before the act came into force, namely that is 2012-2004. 2012-2004 was the date on which the bill was placed before the Rajya Sabha. So any alienations made by the father or brother, or any disposition which had taken place, or any partition which had taken place, or any testamentary disposition which had taken place, cannot be altered after the act came into force on 9/9/2005. Take an example. Suppose the word section 6.5, the word used is final partition, final degree. Mere passing of preliminary degree is only share is ascertained, but the property by meets and bounds will be divided only after the final degree. Therefore, section 6.5 in very clear and categorical terms held that unless final degree is passed, then proceedings are deemed to be pending. Therefore, until the matter is finally the final degree is passed and property is segregated by metes and bounds, by a final degree, then we have to presume that the litigation is pending. Suppose if there was no final degree before 2012-2004, or if there was no final partition between the parties before 2012-2004, then that property is available open for partition even after the Act 2005. So this was the basic and important provisions of this amended Act. Then another issue came up, whether this Act is prospective or retrospective effect. I would say by reading of the provision itself makes it very clear that the Act is only prospective application. There were confusions regarding this applicability, because we have already seen in Sai Reddy, irrespective of the date of the death, the Supreme Court has proceeded to observe when list is pending, then it is a welfare legislation. Therefore, the benefit of the amended Act has to be extended to the pending matters. And nowhere the Supreme Court has gone into the date of the death and its implication in the succession. Therefore, 1990, this Sai Reddy case has been continuously followed by 1991 3 SCC 647, has been continuously followed in Prema. In 2011 6 SCC 462, you already noted. Then 2011 9 SCC 788, Tanduri Kodiswaramma. And the benefit of the amended Act has been extended to the pending matters also. There is no difficulty, can be extended to the pending litigation, provided father should have died after the Act came into force on 9/9/2005. Suppose litigation would have been pending, litigation would have been filed before the Act came into force, but it may be pending after the Act came into force. But in order to extend the benefit, the father should have died after 9/9/2005. If not, then suppose father died before the Act came into force, then the law which was prevailing at the time of death alone will prevail. What is the law prevailing? Except in the state enactments 29A, and the rest of the countries, rest of the states, the 1956 Act alone was there. What is the effect of 1956? We have seen the old Section 6 and proviso. Old Section 6, only co-partners will get the property by survivorship. But proviso says if a female heir is there, then female heir will get the property as class 1 heir along with the other class 1 heirs. Therefore, earlier, take an example of a father died leaving behind a son and a daughter. The earlier position was father and son would get half share. Then the father's half share will be divided again equally between son and daughter. So son will get 3/4, daughter will get 1/4. That was the position prior to the Act. Now, after the amendment 2005, now daughter is also treated as a co-partner. So if a father died leaving behind a son and a daughter, now all the three will get equal right. That is 1/3 by notional partition. Now father is no more. Therefore, father's share will again go to the father and the daughter and the son. So now each son will get half share. Daughter also gets half share. So that is the present position. So whether it is retrospective or prospective, nowhere the Act said whether it is prospective or retrospective. But no doubt, I know all the listeners would agree with me that this enactment is a substantial in nature, because it is substantially dealt with the property of the parties concerned. So virtually, by making the daughter as a co-partner, it affects the right of the son as well as the widow. So now the widow share also considerably diminished because making the daughter as a co-partner. So now the share is apportioned to the daughter also by treating her as a co-partner. So the property right is substantially affected because of this amendment. Therefore, the act should be treated only as a prospective in nature. And we have seen in many places the act itself is very clear. Terms said that on and from the date of commencement of this act. So that wording itself is very clear that the act has been given only prospective application, and the act has not disturbed the past disposition which have taken place before 2012-2004. So if the intention is to give retrospective effect, then the legislature would not have fixed the cutoff date as 2012-2004 to retain the alienations and testamentary dispositions which have taken place before the said date. Similarly, Section 6 of General Clauses Act, you please take note of Section 6 of General Clauses Act, which says that anything done before a new amendment came into effect, then that should not have any implication on the rights which has already been accrued. In effect, a right which has been divested, before the amended act cannot be re-divested because of the amended act. So a right or anything or any property issue which has been settled before the act came into force cannot be allowed to be unsettled retrospectively. It would cause serious prejudice to the parties concerned. In fact, the Bombay High Court in AR 2012, Bombay 101, the division bench has taken the view that the daughters who born on and after 9/9/2005 alone are entitled to become a co-partner. So the division bench has fixed the cutoff date, namely the date on which the act came into force, as the cutoff date, and held that the daughters who born after 9/9 became a co-partner. Then that matter was challenged before, the judgment was questioned before Supreme Court. Supreme Court has dismissed the SLP in the admission stage, but left open the legal issue to be decided in appropriate cases. Under such circumstances, a full bench was constituted in the full bench in AR 2014, Bombay 151, AR 2014, Bombay 151, has extensively dealt with this issue and held that Section 6(1) is only prospective application, and exactly the division bench has, the full bench has said as under Section 6(1)(a), that is, daughter by birth became a co-partner in her own right in the same manner as the son. This has been held as prospective application by the full bench. The other two, 6(1)(b) and 6(1)(c). 6(1)(b), the daughter of a co-partner shall have the same rights and co-partner property as she would have had if she had been a son. So the daughters who born prior to the act came into force also are treated as co-partners. That is why B 6(1)(b) has been worded in such has been worded in such a way to cover the daughters and to treat the daughters who had born prior to the act came into force as that of a son. This has been treated as retroactive. So this 6(1)(b) covers the daughters who had born prior to the act. Therefore, the 6(1)(b) has been treated as retroactive. Similarly, 6(1)(c) be subject to the same liabilities in respect of the co-partner property as that of a son. So this has also been treated as a retroactive. So the entire gamut of this Section 6, post-amendment Section 6, has been tested by the full bench and said that this is only a prospective in nature, and it has no retrospective nature. But retrospective effect has been given to this amended act, then it will result in various mischievous litigation. Take an example. If the act is given retrospective effect, what would happen? The lady who aged 80 years even can be treated as a co-partner, and she will file a suit without unmindful of the fact that the property would have been developed or sold, third party interest would have been created. So many complications are there. Therefore, legislature never intended to give retrospective effect. If their intention is to give retrospective effect, they would have specifically said so in the act itself. Therefore, it can't be given retrospective effect is the view taken by the Bombay full bench. In fact, much before this decision was taken, the Madras High Court in 2012, 5 Law Weekly, 2012, 5 Law Weekly, 378, party name P. Vijayalakshmi. Then another division bench in Bhagirathi case, 2008, 4 CTC, 374. Then yet another judgment in KM Tangavel versus KT Udayakumar. KM Tangavel is KT Udayakumar, 2014, 2 Law Weekly, 113. 2014, 2 Law Weekly, 113. Then in AR 2013, Madras, page 80. AR 2013, Madras, page number 80. In all these cases, the Madras High Court Division Bench and Honorable Singhal have taken the view that the Act is only prospective application. This was the position. But before Supreme Court, we have seen in 2 cases, in Prema and Ganduri Kodiswaramma, Supreme Court has taken the view that once a list is pending, then the social welfare legislation has to be extended to the pending litigations also. While so, the Supreme Court in 2006, 2 SEC 36, 2006, 2 SEC 36, Prakash versus Pulavadi case, Supreme Court has said that the Act has only prospective application, and the Supreme Court has clearly said that the view of the judgment of the full bench judgment of the Bombay High Court has been virtually reiterated by the Apex Court. The same view was also taken. The judgment of Supreme Court in 2016, 2 SEC 36 has been followed by the Honorable Supreme Court in the subsequent decision reported in 2018, 3 SEC, Dhanamma case, 2018, 3 SEC, 343. 2018, 3 SEC, 343. Then, yet another judgment of the Honorable Supreme Court in Mangammal, 2018, 15 SEC, 2018, 15 SEC, 662. 2018, 15 SEC, 662. The Supreme Court has taken a different view. Therefore, now the issue has been referred to a larger bench. Now the matter is pending before larger bench. The reference order is reported in 2019, 6 SEC, 162. The reference order is now is pending, which is reported in 2019, 6 SEC, 162. So we hope that the Supreme Court, based on today, the judgment of Supreme Court in Prakash versus Pulavadi is still holds good. And now the issue has to be resolved once for all by the Honorable Supreme Court in the pending reference. We hope and expect that the Supreme Court would consider the matter in the light of the literal and meaningful and even golden, by applying the golden rule of interpretation. In fact, regarding this prospective and retrospective effect is concerned, the Constitutional Bench in one judgment reported in 2015, 15 SEC 1, 2015, 15 SEC 1 is a Constitutional Bench judgment. Is only this judgment is only in respect of rule of interpretation. Supreme Court has clearly held that any law should be given only prospective application unless the Act clearly says that it is retrospective effect. So the principle of law known as the law looks forward and not back forward. Now, law looks forward and not back forward is the view taken by the Constitutional Bench in 2015. 2015 1 SCC page number 1. It is a judgment of worth reading. Supreme Court has clearly held. In fact, I want to read a few lines of the Constitutional Bench in 2015 1 SCC page number 1. I quote, law passed today cannot apply to the events of the past. If we do something, we do it keeping in view of the law of today and in force, and not tomorrow's background adjustment of it. Our belief in the nature of the law is founded on the bedrock that every human being is entitled to arrange his affairs by relying on the existing law and should not find that his plans have been retrospectively upset. This principle is known as law looks forward and not back forward. So this was the position of law laid down by the Constitutional Bench. So the same view, I hope the Supreme Court is going to take it in the reference which is pending before the court. So always any new enactment should be given only effect in the future and not to the past events. So the events that settled once for all cannot be unsettled by giving retrospective effect is the view taken. Even after this 2005, there are few anomalies in the Act 6. There are a number of anomalies. I will tell one example. We have seen in the section 6 clearly says that any alienation or disposition which had taken place before 2012-2004 cannot be questioned by the daughter who became a co-partner. But son is concerned, he can question. So daughter is concerned, she cannot question. So this itself clearly shows that now the daughter has not been given right to question the partition. She would have some grievance in respect of the partition which had taken place in her absence, or she would have some grievance in respect of the alienations or documents which came into effect before the act came into force. So yes, now son is given right to question it. Daughter is not given right to challenge it. So this view alone was challenged before the wires of this provision was challenged before the Kannada High Court in AR 2010. In AR 2010, Karnataka, page number 27, the Kannada High Court has taken the view that there can't be any distinctive discrimination among the son and daughter when both have become a co-partner. So what are all available to the son is also available to the daughter also because he has been made as a co-partner under the Act 2005. Similarly, there is another anomaly. Suppose what would happen if a daughter co-partner died intestate, whether it would be treated as her property or whether it would be treated as a co-partner property, there is no clarification according to me. Similarly, if a son of a predeceased son, if a son of a predeceased son is a co-partner, son of a predeceased son is a co-partner even under the Act, but not son or daughter of a predeceased daughter. You take an example, even daughter must be alive. They say daughter must be alive. So, if while making the son of a predeceased son as a co-partner, the legislature should have also included the son or daughter of a predeceased daughter as also co-partner. This they have not done it. Then yet another anomaly: if a son dies, the category of heirs are different from the daughter dies. So these are the anomalies. Still, there's a gray area which is yet to be examined by the legislature as well as the court in the days to come. So these are all the basic effect of the amended provision. In fact, in between the judgment of Honorable Supreme Court in Uttam case 2016 4 SCC 68, 2016 4 SCC 68 has come. In that case, already property, there was why I am laying this judgment. There are two views. One view is that if a father died before the Act 1956 came into force, then co-portionary goes, and the son gets the right, son or daughter gets the right only in his individual capacity and not as a co-partner. But there are another thinking which says that whether father died before the Act 56 or after the Act 56, son or daughter would still retains the property as a co-partner. So these are two conflict views have come. In fact, this view has been referred to, discussed by number of decisions. You please one view of the Supreme Court in the following three decisions, namely 2006 8 SEC 581, 2006 8 SEC 581, 2008 3 SEC 87, 2008 3 SEC 87, 2009 15 SEC 184. In these three judgments, Supreme Court held that when succession opens before the 1956 Act, then son or daughter, at the time son was there, now daughter also elevated to the position of co-partner. So therefore son or daughter who got the right, 2009 15 SEC 184. The daughter who got the right after the Act 1956 gets it as only her his or her separate property and not as co-partnership property. This was the one view. The another view of the Supreme Court is that in 2007 5 SEC 561, 2007 5 SEC 561, 2013 9 SEC, 2013 9 SEC 417, 2016 2 SEC 36. In all these judgments, Supreme Court has held that irrespective of the fact whether father died before or after, it makes no difference. The status of co-partnership will continue even after the Act came into force. So the one view was, once succession opened prior to the Act came into force, then the property reached the hands of the son and daughter will not be treated as that of the co-partnership property or joint fund property. The other view was that even after the Act came into force, it will be treated as joint fund property. In fact, there was a reference to this aspect. That reference was withdrawn on the ground that the matter has been settled between the parties. So now the confusion still continues. One view, there are few judgments which says that even after 1956, co-partnership continues, irrespective of the fact whether father died before 1956. Another view, father died before 1956, guarantees the matter, co-partnership goes and the property reaches the hands of son and daughter as that of this individual property. So these are all the positions in respect of section 6 is concerned, prior amendment, subsequent amendment. Yet another view is important. When suppose we have seen that son, suppose there was a partition in the family, we have seen notional partition theory. Similarly, if there was a partition in the family, take an example, a father and son both had entered into a partition. So property of halves are given to father, another halves are given to the son. So once property comes to the hands of son, that the property which reached the hands of the son, no doubt it was an financial property, co-partnership property, but he gets it as he holds it as a separate property. But the moment son gets a son, son gets a son or daughter, and son or daughter born to him, the share which was given to the son in the partition will automatically gets into the category of the co-partnership property. An example I will tell you: A father, B son. there was a partition between A and B. 5 acre was given to father A. 5 acre was given to son B. Son gets it as that of his separate property. No doubt it was originally ancestral property or co-parental property. He gets it in the partition. He married later. He gave birth a son or a daughter. The moment a son or daughter born to him, then the property which was allotted to the father gets converted as co-parental property, in which the grandsons, that is B's son and daughter, have no have right as a co-partners. But the property which was allotted to the father, namely A, will not be treated as co-partnership property. The property which was given to the divided father, namely A, will be that of his separate property. He can dispose it off as he likes. Once he died intestate, that 5 acre which was given to the father A will come to the son B as separate property, in which that in the 5 acre which comes to the hands of B from his father will not be treated as that of the ancestral property, because already family had divided, partition had taken place. So the children of B can claim only in the share of the father B. The children of B have no right to claim share which was given to the grandfather, namely A. So, in the event of a suit has been filed by at the instance of the son or daughter of B, then they can claim right only from the share which was given to the B. They cannot claim the property which was allotted exclusively to the father. So here there are two mode of division. One, B gets 5 acres in the partition as that of ancestral property, and he constitute a co-partner along with his son and daughter. That is one aspect. Similarly, B gets another mode of property, namely separate property, namely that is the 5 acres which was given to the father. So there are two mode of division which was given to B. So this position clearly discussed by the full bench of the Madras High Court in AR 1979, Madras page number 1. No doubt it is a judgment relating to income tax, but still the law on this subject has been elaborately considered by the Honorable Supreme Court, the Honorable Full Bench in AR 1979 Madras page number 1, and full bench judgment. That full bench judgment still holds good, and it has been repeatedly followed by the other judgments also. In fact, the very judgment of full bench 1979 Madras page number 1 was the subject matter in challenge before Supreme Court, and the Supreme Court has dismissed the SLP in a reported decision in 1993 Supplementary 1 SEC, 1993 Supplementary 1 SEC 580, 1993 Supplementary 1 SEC 580. So the full bench judgment was virtually upheld by the Honorable Supreme Court. Before it was upheld, there were two other decisions came before Supreme Court. That is 1986 3 SEC 567, 1986 3 SEC 567 Chandrasen. In Chandrasen, Supreme Court has virtually reiterated the principle of law laid down by the full bench in AR 1979 Madras page number 1. Similarly, the very same judge, Honorable the judge who authored the Chandrasen in 1986 3 SEC 567 has again reiterated the same principle in 1987 1 SEC page number 204 in Yudhishthir case. 1987 1 SEC page number 204, party name Yudhishthir. And this principle has again followed by the Honorable Supreme Court in 2018 7 SEC, 2018 7 SEC 646. 2018 7 SEC 646. There are two mode of divisions. One by applying section 6, another by applying section 4. So another by applying section 8. So there are two mode of succession has been discussed by the Honorable Supreme Court in the said judgment. In fact, the Madras High Court has taken note of all these conflicting views, and in a celebrated decision reported in 2017 3 CTC 170, 2017 3 CTC 170, the Honorable Single Judge of Madras High Court has thoroughly examined the entire position of law on the subject and issue, and held that the view of the full bench of Madras High Court in AR 1979 page number 1 will prevail. And in fact, the law on this subject, including the decision which I have referred to, except this 2018, the rest of the judgments of the Supreme Court have also been taken note of, and the position of law has been reiterated in the said judgment. Now, let us go to the next provision, namely section 8. So, section 6 is concerned, we have dealt with pre-amended, post-amended, as well as the state amendment. Now, section 8. Section 8 is concerned, absolutely there is no difficulty to understand, because it deals with general rules of succession in case of males. As I have already said, this section 8 is this section 6 is an exception to section 8. In the section 8, the property of a Hindu male dying interstate shall devolve upon according to the provisions of this chapter.
Mr. MANOKARAN, how much time do we expect on this particular talk on section 8?
I hope another 20 minutes I will cover the entire rest of the provisions.
It's fine. It's fine. Then it's fine.
So section 8, there are a number of categories. It says 8A, firstly upon the heirs being relatives in class 1. So in the event of male Hindu dying intestate without leaving any testamentary disposition, then rules of succession, that is, this is relating to separate property or self-acquired property. We have already covered the co-possession property in section 6. So this is relating to the separate or self-acquired property. A male Hindu dying intestate without making any will or testamentary disposition, then the heirs available in class 1, that is class 1 of the schedule, will get the property equally. If there are no class 1 heirs, then the property will, secondly, if there is no heir in the class 1, then the property will go to the class 2. Class 2, there are a number of categories. First category, father, then brothers, and there are a number of categories. Then 8C, if there is no heir of any of the two classes, then to the cognates. Lastly, to the cognates. Cognates and cognates have been defined under section 3A. Cognate is under section 3A. Cognate defined under section 3C. Cognate is a close blood relative, comes under this 3A. Cognate means not only blood relatives, and even the strangers who gets right over the property will come under the cognate. So this is the position. Regarding this 8 is concerned, one leading decision of the Honorable Supreme Court is in 2008, 3 SEC 87. 2008, 3 SEC page number 87. Supreme Court has dealt with the scope of section 8. Then section 9 and 10. Section 9 deals with the order of succession. How the succession in the male Hindu gives effect. Section 9 says, among the heirs qualified, specified in the schedule, those in class 1 shall take simultaneously unto the exclusion of other heirs. So, heirs in class 1 will get the property equally in the event of male Hindu dies intestate. Then 10 deals with the distribution of property in class 1. the property of interstate shall be divided among the class 1 heirs according to the following rules. There are rules specified under. Similarly, if there are no class 1 heirs, then the property should be divided among the class 2 heirs, which is set out under section 11 of the Act. So 9, 10, and 11 all deals with them how the class 1 and class 2 heirs of a male Hindu dying intestate should divide the property among themselves. Then section 12 deals with the cognates and ognates. Then 14, section 14 is a very important provision next to section 6. 14, we have already seen the Women's Right to Property Act 1937. The widow was given right in recognition of her pre-existing right, that is maintenance right. So that right which was given prior to the act came into force, automatically blossom into the absolute right. So the limited right which was given to the Women's Right to Property Act was given only limited estate. So that limited estate has blossomed into absolute estate, and thereby he gets it as that of she gets it as that of her absolute property because of section 14(1). And 14(2) is an exception. Is an exception to 14(1). Suppose the property which has been given after the act came into force with the restrictive right under any document, settlement, or will, or any court degree with the restrictive estate. The section 14(1) deals with the limited estate. Section 14(2) deals with the restricted estate. So 14(2) is an exception to section 14(1). And there were a number of confusions. The Honorable Supreme Court in Tulsamma case, 1977, 3 SCC, page number 99. 1977, 3 SCC, page number 19 is a leading judgment of the Honorable Supreme Court. We should read the judgment at least first 10 or 10 paragraphs. The Supreme Court has elaborately dealt with how we have worshipped the women folk in the earlier point of time, and even many areas in our country, still that women folk are even being worshipped as goddess. Therefore, the Supreme Court has discussed the law on this subject and held that the only given interpretation to section 14(1) and 14(2), and this judgment still holds good, even though there are number of judgments have come and slight deviations have been made. But according to me, this whenever section 14(1) and 14(2) comes up for consideration, you can kindly make use of this 1977 3 SCC, page number 99, equivalent to AR 1977 Supreme Court 1944. AR 1977 Supreme Court 1944. Then let us go to section 15 and 16. Section 15 is like that of section 8, which applies, which is applicable to a male Hindu dying intestate. Here, section 15 deals with the general rules of succession in case of female Hindus. 8 deals with the male Hindus. This is relating to female Hindus. In 15(1), a list of legal heirs are set out in section 15(1). Take an example. 15(1)(a). Firstly, if the property of a female Hindu dying intestate shall devolve according to the rules set out in section 16. 16(a) says, firstly, upon the sons and daughters, including children of predeceased and the husband. So similarly, the other categories are there. 15(2) is an exception to 15(1). Take an example. 15(1)(a) says, if a female Hindu gets some property from her parents after her death, in the absence of any children, it should go back only to her parents. That is the source from which she got it. It should go back to that position. That is almost like doctrine of reversioner. So female got some property from her parents and she died intestate, leaving behind no children. Then the property will again go back to the source from where she got it. 15 to B says, suppose a property, a female Hindu got some property from her husband or father-in-law, then the property which she got from her father-in-law and husband, if she died intestate, that property will again go back to the place where she got it. So this is the position set out under section 15. An important decision of section on section 15 is 1999 4 SEC, 1999 4 SEC, page 86. And section 16 deals with the order of succession and the manner of distribution among heirs of a female Hindu. So this is all rules. Distribution of interstate property of a female Hindu is set out, section 16. And section 20 deals with the right of a child in a home. So even when child, a child is yet to born, is also entitled to get right under section 20. Then section 22, preferential right. Section 22 is concerned. Earlier continuous view of all the courts in India was that it has no application to the agricultural lands. So that was the view prevailing from 1956 till 2019. So section 22, preferential right, has no application to the agricultural lands. That view is no longer good law, because now the Supreme Court has on reference, there was a reference to that in AR 2019 Supreme Court 1506. AR 2019 Supreme Court 1506. The Supreme Court has referred the matter to a larger bench. Now the larger bench has answered it in 2019 14 SEC 162. 2019 14 SEC 162. So now the section 22 is also applicable to the agricultural lands also. Then section 25, murderers are disqualified. Section 23 and 24 now removed. That is 23 dealt with dwelling house. Now because of the 2000 Act, it was repealed. 24, widows remarrying, remarriage, now that provision has also been deleted. Section 25 deals with murderers are disqualified. 26, converts descendants disqualified. Suppose if a person has ceased to be a Hindu, he will get the property, but not the legal heirs born to him. So that is section 26. Then section 30, testamentary succession. That we have already dealt with. Male Hindu is entitled to, any Hindu, male or female, is entitled to deal with his or her property by way of testamentary disposition, which is permissible in law. So these are all the major sections in which we have almost covered. Take an example. Suppose a person has projected as if the property is a co-possession property or ancestral property. Burden lies on whom? That is a very important aspect we have to take note of. I will finish it within 2 minutes. The law has been well settled by the Honorable Supreme Court in AR 1954. AR 1954 Supreme Court 379. AR 1954 Supreme Court 379. And the latest one, 2011 5 SEC 532. 2011 5 SEC 532. There are a number of judgments in between. Let me not trouble you by citing all those decisions. And 1954 is a very classic judgment by Justice Vivian Bose. His lordship has laid down the once a person has come with a plea that it is an ancestral property or co-possession property, and he has prima facie established, the very moment he has established his case prima facie, there ends the matter, then burden always shifts upon the other side to say that it is to show that it is an ancestral, or it is not an ancestral property, or it is a separate or self-equity property. So this is the position of law. Yet another aspect, a Hindu is not supposed to deal with his co-possession property by way of a gift. He can execute sale deed, he can execute a lease deed, he can mortgage the property, but he cannot execute a settlement deed. He cannot execute a gift settlement deed. So gift is totally prohibited in respect of undivided share is concerned. So no Hindu is entitled to execute. No Hindu male is entitled to execute a gift deed in respect of a co-partner property without the consent of the other co-partners. This position of law settled by the Honorable Supreme Court in 1987, 3 SCC 294. 1987, 3 SCC 294, equivalent to AR 1987 Supreme Court, AR 1987 Supreme Court 1775. Supreme Court has made it very clear case and held that gift in respect of an undivided co-partner property is void. It need not be even challenged. It is a void by its nature itself. But one exception, Supreme Court has carved out an one exception only in 2004, 1 SCC 295. 2004, 1 SCC 295. A co-partner is entitled to execute a gift in respect of a reasonable portion in favor of a daughter for towards Sitana or at the time of her marriage. So even father has no right to deal with the entire property. The father has no right to execute a settlement deed in favor of wife or mother, whereas father can execute a settlement deed in respect of a limited and reasonable portion in favor of a daughter, as held in 2004 1 SCC page number 295. What is reasonable extent has to be decided in the facts of that particular case, is the view taken by the Honorable Supreme Court. Yet another issue, whether illegitimate son are entitled to get right equal to that of the legitimate son. Now the view consistently taken by all the courts, including Supreme Court, is that illegitimate sons are entitled to get share only from the share of the that is separate property of the self-equity property of the father, and the illegitimate son are not entitled to get share in the ancestral property and co-partner property. This view now doubted by the Constitutional Supreme Court. Now that is also pending way of reference report as reported in 2011 11 SCC page number 1. So now whether illegitimate son is entitled to get share or not is an issue now which is pending in reference in 2011 11 SCC page number 1. Finally, suppose a property has been dealt with by the father for and behalf of minor. If a minor has been shown as eo nominee, that is a party to the document, in the event of any challenge to be made, then son has to challenge it, challenge the sale as null and void by asking for a specific prior in the suit for partition. If a father has dealt with without showing the son as a party, then son has no necessity to challenge the sale deed. Mere general suit for partition is enough. So if a minor was shown as eo nominee party, then it is necessary to challenge it. If a son has not been shown, the father has dealt with as that of his own property, then there is no obligation on his part to challenge the same. So these are all the basic things. I hope I have tried my level best to deal with the entire subject. In fact, when 1933, a jurist had sent a letter to our father of nation, Mahatma Gandhi. He asked him to give a solution as to how this family quarrels and property disputes can be resolved in a ahimsa way. Then Mahatma Gandhi sent a letter in reply in one word: unless the brothers have changed their attitude, then this problem will go forever. This was the answer given by our father of nation in 1933. Now we are in 2020. Still, the attitude of the brothers have not changed. That is why the legislature have enacted one after another, and problem continues forever. With this, I conclude. Thank you. Thank you very much.
Sir, the session was quite engaging. As you had at the outset stated that we will primarily go to the nitty-gritties of Section 6, the effect of pre-amendment and post-amendment. That has been well taken. But the way the people were glued with the entire session, it shows that we would have to have another session beyond Section 6, where Section 6, we can have a bird eye view because mainly people have heard it. And then rest of the sections, we can have another session so that the people are actually enlightened. They will understand the nitty-gritties of the both. Like
Yes.
one word though I have understood, but you had used the word of retroactive. As a student of law, I know that invariably people know what is the meaning of retrospective. Would you just elaborate what is retroactive? Because I feel that large number of people will not be knowing what is retroactive.
Yes. I will suppose if an act has come into force, take an example, the Hindu Succession Act. The act itself is very clear terms said that on or after the act came into force, that is from the date on which the act came into force, then it should be treated as prospective in effect. Take an example. Suppose the act has covered the past transactions also, as held by the Supreme Court in Sairati case. Even the new act which came into force subsequently has been applied to the suits which were pending already. So, irrespective of whether succession opened before that or after that, the benefit of this act has been given retrospective effect to the pending proceedings. That is retrospective effect. Retroactive means in a clear example is there in section 6 1 B and C. 6.1 6.1a we have already seen. 6.1a says that the daughter of a co-partner, I am again referring section 6.1a of the amended act. The daughter of a co-partner shall A by birth become a co-partner in her own right in the same manner as that of a son. So her right and her birthright has been crystallized only from the date on which the act came into force, as per section 6.1a. That is why it is prospective in nature. Retroactive. What is called retroactive? 1b and c. Let us read section 6.1b. The daughter of a co-partner shall have the same rights of the co-partner property as she would have had if she had been a son. So it covers the daughters who were born before the act came into force. No doubt the act has come into effect only on 9/9/2005. But the very wording of a section says that she would have had as if she had been a son. So we have to treat this daughter as that of the son, even though she might have born prior to the act came into force. Therefore, this is called retroactive. And this position has been well elaborated by the full bench in AR 2014, Bombay 101. The very same the interpretation which now I have given is not my interpretation. It's the interpretation given by the Honorable the full bench of the Bombay High Court in AR 2014, Bombay, page number 1. The same view was again reiterated by Supreme Court in 2016 to SEC, page number 36. That is the position, sir.
So thank you. As what I said, that I have always been saying on the platform, whenever the participants continue to remain glued, it shows that people are actually enjoying it. So we had a large number of participants actually who are joining, even though courts, universities, etc. have opened. It shows that people had quite keen interest. Therefore, we had thought that we should have a second session on this aspect. It's a well-received session. Now, 2-3 questions only we will be taking, since we are already gone beyond what was the scheduled time.
Yes.
Bimla Bhai, can a Hindu widower execute the will to who is taking care of him, but the property is transferred to him through a special power of attorney, which is not registered?
Sir, as far as any Hindu male is concerned, there is no hurdle for him to execute a will in respect of his separate and self-acquired property. There is no hurdle. He can execute in favor of any person. There is no difficulty at all. He can even execute in favor of a stranger. You know well, the very purpose of will itself is only to deviate from the normal rule of inheritance. That is why he can execute in favor of any person. That is one aspect. Second, suppose if he wants to deal with co-possession property, the will in respect of his share alone is valid, not in respect of the entire property. That is the basic thing.
Mr. Ajay asks, Ajay Dev, the amendment effected in section 6 of the Hindu Succession Act, is it in consonance and for the purpose of giving effect to articles 14 and 15 of the Constitution of India?
Certainly, sir. If you read the very purpose and object of this preamble of this amended act, Yeah, yes, the listener asked, the legislature have taken note of section 14 and 15 and held that in order to eliminate this gender discrimination, this amendment has been brought in. Therefore, it is only in line with the article 14 and 15, sir.
So, Mr. KP Jain, an unmarried girl adopts a child. After that, she gets married. Had the child and her mother and her husband died intestate, how the property will devolve?
Sir, could you read again, sir?
An unmarried girl adopts a child. This is the first part. That unmarried girl adopts the child. After that, she gets married and has a child, but her husband dies intestate. How the property will be devolved?
No, this has various legal ramifications. First, I have my own doubt as to how an unmarried daughter could adopt, and if this adoption should have endorsed by this husband who married later. So unless this adoption is accepted by the husband who got married later, then question of the extending the benefit of the property which is available at the hands of the deceased husband cannot be extended to the adopted son. So it has various ramifications. We have to look into the entire background and legal provisions for giving any concrete answers, sir.
A Hindu male files partition suit in 1998 in Delhi against B. He has two children, one son, one daughter. A dies in 2010 and suit is decided in 2020. Will the daughter get share in property?
Sir, 1 minute. When the suit was filed, sir?
1998. But he dies in 2010.
Whether property is ancestral or separate property, sir?
That Sahil posed that question.
Sir, suppose the father died after the act came into force. Probably suit would have been filed before that. But when the act came into force, if the son and daughter both are alive, then daughter is also entitled to get equally as that of the son. Suppose father died before the act came into force, then the daughter will be treated as class 1 heir. If it is a ancestral property, if it is a separate property, there is no difficulty at all. All the legal heirs are entitled to get equally, sir. There is no difficulty because in the question it is not clear as to whether it is an ancestral property or it is a separate property. If it is an ancestral property, the father is alive as on 2005, then all are she is also entitled to get as co-partner. If it is if he died before the act came into force, then she will be treated only as a class 1 heir.
So, this question time and again people have asked. Could you explain Gurupad versus Hirabai case of 1978 in relation to notional partition theory?
Gurupat case in 1978, 3 SEC 383, authored by Honorable Justice Senior Chandrachud, has created a lot of confusion that has also been clarified by the Supreme Court in the subsequent Narayan Rao case reported in 1985, 2 SEC page number 321. 1985, 2 SEC page number 321. In the said judgment, while applying the notional partition theory, the Honorable Supreme Court in Gurupat case said that the moment suit is filed by applying the notional partition theory, severance of the status has come into effect. That was the view taken in the Gurupat case. That view has been held as applicable only to the facts of that particular case that has been well clarified by the 3 judges bench of the Supreme Court in 1985, 2 SEC 321. In fact, the very same judgment has again come up for consideration in the very recent decision of the Supreme Court, AR 2019, Supreme Court 3098. AR 2019 Supreme Court 3098. In these two decisions, Supreme Court has held that the Gurupat case is no doubt it has not been expressly overruled, but Supreme Court has held that Gurupat case is applicable only to the facts of that particular case and it cannot be traced or law laid down. So you please read 1985 2 SEC page number 321. It exactly dealt with the Gurupat.
This is on the Facebook. Karthik asks, after legal adoption, whether father has a right to write a will to some other person.
Yes, sir. No difficulty at all. If it is for separate property, he can deal with it. The very purpose of will itself, again reiterating, is only for the purpose of deviating from the normal rule of inheritance. Therefore, no difficulty at all in respect of separate or self-custody property. If it is in respect of ancestral property, then he can execute a will only in respect of his share in the co-portionary.
Thank you, sir. The questions will continue to pour, but ultimately we have to maintain the essence that it has been a wonderful session. The words cannot express the manner in which the doubts, if any, in the mind of a person who has already dealt on this field, dwelled on these issues, his certain issues would be clarified. And one who has done it attending for the first time, or he just had some issues regarding which, but after this session, his doubts would be cleared and he can also have a better insights, because they say once you understand the issue, then even the judgment is more understandable. I, on behalf of Beyond Law CLC and ULS Punjab University Chandigarh, thank you for a engaging session, though it was for around 2 hours because we started at 11:30 and now it's 1:35. But once you were making the points in a seamless manner, it was never realized that it was a 2 hours. It was very engaging, which gave deep insights to this thing. Tomorrow at 5 o'clock, we have a webinar on animal protection law in India. And the keynote speaker is Justice A.K. Sankaran Nambiar, a sitting judge of the Kerala High Court. So tomorrow, do stay connected. For meeting IDs and password for tomorrow's session, you can follow our page on the Facebook, that is Beyond Law CLC, or the Instagram, or you can also join the Beyond Law CLC WhatsApp group for the latest updates. For the videos of the previous session, including this session, the previous sessions are already uploaded on the website, as well as the YouTube channel. You can watch that, subscribe that, and like that, so you will have the latest. And this session would also be uploaded on the YouTube channel. Stay connected, stay safe. We are all thankful to Mr. N. Manokaran.
Thank you.
And all the participants, we are also thankful to you that you heard it patiently. Your zeal to have the knowledge gives us a trigger that we should do the webinars, so that, as we say, that sharing is caring. Thank you, everyone. Stay blessed, stay home. And all those who want to get their numbers connected, they will have to connect on the WhatsApp number and not on the Zoom chat. Thank you. Thank you, everyone. Right. Can I be referring this?